Hi, this is Attorney Ted Gudorf. Welcome to the Family Estate and Legacy Program podcast. This session is intended for you to listen to it prior to what we call your delivery or signing meeting with your legal team. Remember, this is step 4 of the process. Congratulations on making it to the signing meeting. You've worked hard. You submitted the client organizer to us. You met with us in your goals and responsibility meeting. You've designed your estate plan, and now you're ready to sign the legal documents that we have prepared for you. Since our design meeting, our team has been diligently working on preparing all of the legal documents. After we prepare those draft documents, we go through a special review process, making sure that those documents are exactly what we need to have in place for you based upon your design. It is critically important that you show up on time for this delivery meeting and you not reschedule, because prior to this meeting, we will have printed out all of the legal documents and have them organized and prepared for signature, dated for your signing date. So it's critically important that we make sure that you attend. We want to make sure also that you're prepared for this meeting. So this podcast is intended to prepare you for the meeting and make sure that there is a sufficient confidence and clarity with respect to moving forward. The good news is that upon arriving at your signing meeting, the first thing our legal team is going to do is to show you an easy to read diagram. That diagram will be a critical document, not only today as we sign your estate plan, but also in the future when you come in to do reviews. We will always be referring back to this diagram. While it's true that the diagram in and of itself is not a legal document, it does in one page outline the basic structure of your estate plan. We will also use this diagram when we get to step 7 and conduct a family meeting or a successor trustee meeting. That diagram will outline for you the name of your trust or trusts, the name of your trustees, who is the trustee while you're alive and well. It will identify who are your beneficiaries upon death. It will also identify who your remainder beneficiaries are if you're a married couple when both of you pass away. Perhaps it will also identify your retirement accounts and will identify what is to happen, again, if you're a married couple at the first death, and also what will happen at the second death with respect to your remainder beneficiaries. If we did elder law planning for you, that is, we created an irrevocable trust, or we did estate tax planning for you and created an irrevocable trust, or we did some sophisticated asset protection planning for you and perhaps created both a limited liability company and an irrevocable trust called an Ohio Legacy Trust, that will be outlined again on the easy to read diagram, and the identification of who is creating the trust, who is the trustee, and who are the beneficiaries of that trust will be designated on that diagram. Once we go over the diagram, then we're going to proceed with showing you the binders that we've prepared for you. We specifically have taken your red binder that we give you to hold all of your legal documents, and we put a label on each of the binders so it's easy to identify what's in each of the binders. In addition to the binders, you'll see when you come in that we have specifically prepared some customized portfolio tabs to identify the various legal documents that are a part of your estate plan. It's important not only to you but to us that we have all of these documents in one place and properly organized one after the other. Now, once we have gone through the binder and shown you the tabs, we will then have an opportunity to go over the specific legal documents. Now, as a matter of law, it is not required for you to sit here and read every single document word for word. The law simply requires us as your attorney to give you an overview of those documents, point out the relevant sections of those documents, and identify what they're attempting to accomplish. Our overall goal today at your signing or delivery meeting will be to make sure that you understand the nature of your estate plan, give you a general overview of that plan, and then give you some identification of what the next steps in the process are once we get these documents reviewed and notarized. Simply put, our overall goal is to get your estate plan put into effect on the date of your delivery or signing meeting. And then we will also begin the process of transferring assets into your various trusts that we've created for you. So when we go through the legal documents, depending upon what office you're in, we may broadcast those documents up on our large TV screen and go through them with you, or we'll simply have hard copies of the documents and go through them accordingly. The first document, and probably the most important documents that we want to go through, are your trust. If you have a revocable trust, we're going to take you through the first part of the trust. The good news is that our trusts have been designed to be very easy for you to read. The publisher of these documents has done a great job of trying to remove as much of the legalese as is possible from the documents so that both you and we can have a conversation about the meaning of some of the specific terms without it being overly complicated. They've also arranged our documents in a way where they're easily readable. So many of the documents that I see, particularly trust documents from other law firms, are not easy to read. They're oftentimes in small print, they're single-spaced, they don't contain paragraphs, they don't contain headings, they don't contain articles or sections. You probably know by now that our law firm is a member of Wealth Council, which is a very unique organization, a national organization of about 5,000 estate planning attorneys. And Wealth Council is the one who publishes our software. They write our software, they update our software regularly. And of course, all the 5,000 lawyers who utilize the software on a continuous basis provide feedback to improve those documents. Our software, while it costs a lot of money, it's the best in the country. It's the best we can get. Now, the trust document itself, you'll see, is organized by articles and sections. And there is a logical, progressive order. We're going to take you through the first part of the trust document because that's the most significant part of the document. The latter articles will allow you to read in your leisure, recognizing that those documents or those provisions in those latter articles are mainly for the lawyers when they're going to administer the trust upon either your incapacity or your death. But we'll do a detailed review of the trust. We will identify who the trust makers are. We will identify who the beneficiaries are. We will identify who the trustees are. We will identify who the remainder beneficiaries are. We will go into that in some significant detail and give you some clarity and some confidence that this trust is designed to accomplish what you indicated to us in your design meeting. Now, along with the trust itself, next to the trust or adjoining to the trust is a section or a tab that we call personal effects. And it is important that we simply point out this is where, if you have items of sentimental value that you want to give to a particular person, you'll have the ability to fill out the personal effects tangible personal property memorandum, and you'll be able to list perhaps a wedding ring or a particular gun or something like that you want to give to a beneficiary. You'll be able to do that on the personal effects page, and at our meeting we will point that out to you. Now, many of us need to understand that we also do a will, a special type of will you'll be signing. It's called a pour-over will. Now just remember, even though we're doing a trust for you, we're also going to do a pour-over will as a standby document. Why do we do that? Well, truthfully, if the trust owns everything that you own, there is no need for a will. In fact, our goal is to never use your pour-over will. Having said that, we still do one just in case you buy something and forget to put it in the name of the trust. It will then have to go through probate through the pour-over will. Now, the pour-over will simply say, put it into my trust after I pass away. Now, also at the signing meeting, after we review the trust, after we review the personal effects page, after we review the pour-over will, we're going to also show you the certification of trust that we utilize in the funding process. That's a critical document. It's a 2-page document, but is really critical. We will also review your financial power of attorney. This is a durable power of attorney. It is intended to take effect immediately. It is intended to survive your incapacity, and it will designate typically those individuals who are your successor trustees to be able to also make decisions on assets that are not owned by the trust. For instance, your IRA or your 401k. Remember, they are not owned by the trust. So if you become incapacitated and we want to access those funds, we have to have a valid power of attorney. So we will review the terms of those powers with you. Suffice it to say, here at our office, typically when we're designating someone to be our agent under a power of attorney, we're going to empower them to do all things that the law will allow them to do. That includes things like filing of your tax return, changing beneficiary forms, having access to your IRA accounts, your life insurance, things of that sort. After we review the financial power of attorney, we're also then going to get into reviewing all of the medical documents that we previously talked about. We have designed and we're ready to implement and sign your healthcare power of attorney, your living will, your HIPAA authorization, and in addition to that, we're going to ask you if you want to be an organ or tissue donor, and if you do, whether you wish to specify on the organ and tissue donor section specific purposes for which they can utilize your organ and tissues, or whether they can utilize whatever they want, and or whether there are specific organs that you want to specify that they can't have. You have the ability to do that. The organ and tissue form is something we send to the Bureau of Motor Vehicles on your behalf. So the medical documents are critically important. Remember, the HIPAA, H-I-P-A-A form is designed to give other individuals, whoever you advised us in your design meeting, that you want to be able to talk to your doctors, have access to your medical records. We're going to list them on your HIPAA form. The healthcare power of attorney is designating other individuals, up to 5, typically in successive order, to make medical decisions for you. And then that living will is talking about end of life. If you're found to be permanently unconscious or terminal, are you willing to authorize your attending physicians to, in essence, end all extraordinary measures that are being used to keep you alive? That is why it is called an advance directive. Sitting here today, while you're alive and well, you have the ability to indicate whether you do or don't want to empower your physicians to, in essence, pull the plug. By the way, it includes making a decision on whether or not intravenously provided nutrition and hydration can be withdrawn. So after we do the medical documents, we're then going to move into reviewing with you the funeral planning documents. On the one hand, we're going to show you where you're going to designate someone to do your funeral and burial arrangements. Again, you've identified those individuals previously. In addition, we're going to show you something where you can actually go into the document and plan out your funeral and burial. It is something that we've pulled together for all of our clients, and we find that to be very helpful. So at the end of the day, what we want to make sure of is that we've got all of those documents reviewed. And then at the end of the day, what we're going to do, assuming that you're comfortable with those documents, we are going to proceed with having them signed by you, and if your spouse, if you're a married couple, by your spouse. So we'll sign the documents. Most of them, but not all of them, have to be notarized. Some will require witnesses. We will make sure that we follow all the proper procedures to get those documents not only reviewed, signed, but also notarized. Now, one of the things that we also start doing once the documents have been signed, say the trust or trusts have been created, we then want to always make sure that we transfer your real estate into your trust or limited liability company, depending upon how your plan is designed. But we want to go ahead and sign the deeds on the date of signing. That has been a common practice at our firm for many, many years. We want to begin this funding process on the date of signing, and we begin the funding process by making sure all of the real estate, to the extent possible, gets funded on the date the trust is signed. Now, if you own property that is out of state, perhaps it will take a little bit more time to get that accomplished. But if you notified us of that ahead of time, more likely than not, we will have that deed ready to be signed so that it can be processed on a timely basis. Also, it's a good time to just make sure that you informed us of all the real estate you own. Just remember, we do have to fund timeshares. If you have a partial interest in a piece of property, that can also be funded on your behalf. Now, in addition to making sure that the deeds are signed on the date of signing, in every instance, we also make sure that we fund or align your tangible personal property into the trust itself. How do we do that? We do that by having you sign an assignment. What's tangible personal property? Well, it's everything you own that basically doesn't have a title. It's everything from your clothing to your household furnishings and things like that. It doesn't include any titled property as a practical matter. So we're going to make sure that this process necessarily involves you having reviewed all of the legal documents that we've prepared, that you've signed all the legal documents to create the estate plan, and then we're going to begin the funding process. All total, the meeting for most plans will take less than 2 hours. Having said that, if it's a more complicated plan where we're creating multiple trusts or multiple limited liability companies, it may take up to 3 hours. But as a general rule, for most plans, it's going to be under 2 hours. Now, at the end of the meeting, there's still a few things I want to give you a reminder of. Remember, at the end of this meeting is when we are expecting for you to make full payment for your estate plan. So don't forget to bring your checkbook along, or if you're going to put it on a credit card, make sure you accomplish that, number one. Also, we're going to review with you our benefits of our Legacy Club. Remember, our Legacy Club is a part of Step 7. And as a part of our maintenance program, you're going to be a member of our Legacy Club for 1 year from the date of your signing. It is included at no additional charge. Remember, that Legacy Club now enables you to have regular contact with our office. Might be a face-to-face meeting, a phone call, an email, a text message about your estate plan, more likely than not about funding your estate plan, for the course of up to 1 year at no additional cost. We want to encourage you to communicate with us, communicate with your legal team, communicate with our entire team about your estate plan. So the first year of that Legacy Club is included within the fee that you paid us, and there is a small nominal additional fee that will be due in January of each year to the extent you want to continue to receive all of the benefits of the Legacy Club. We will review the Legacy Club membership benefits with you at the signing meeting. The last thing we want to do is at the meeting is go over the asset alignment workbook. We're going to give you the workbook and ask you to review it, and then we're going to schedule you to attend the asset alignment workshop. Now, the asset alignment workshop is a critical component of every estate plan that we do. Just remember, the key to an effective estate plan is funding of these trusts. We want to make sure that you understand the importance of funding, and therefore we've set aside time 6 times during the year where we offer up an asset alignment workshop. The workshop typically is from 6 to 8. Oftentimes it'll be on the 4th Tuesday of a particular month. It will last approximately 2 hours. Now, during that workshop, we're going to get into the nitty-gritty details of how to put assets into the trust. We're going to talk about how to take assets out of the trust. We're going to talk a little bit about continuing trusts that you may have created for the benefit of your children or grandchildren. If you have a limited liability company, we're going to talk about that. A handful of other things also will be discussed at that asset alignment workshop. But that workshop is absolutely critical. Please, when you attend your delivery or signing meeting, please have your calendar with you and be prepared to schedule. So after we're done reviewing the plan, signing the plan, and doing some partial funding and doing some scheduling, the very next and last thing that we're going to do is we're going to take the signed documents and we're going to scan them. You see, at our office, we do not keep any original client documents. We want you to be the holder of those documents. So instead, what we're going to do is we're going to utilize our scanners and scan those signed documents into our system, and then we will maintain those documents in our client portal. Now, I will tell you this, that if you want other family members to have access to your scanned documents, we can do that through our client portal. Just let our legal team know that you have an interest in that. And if you aren't sure now whether you do or not, just remember that as a part of Step 7, where we do our maintenance program, we're going to offer up for you an opportunity to have a family meeting. And maybe at that time we can ask your kids whether they do or don't want to have access to any of these legal documents. Well, look, I hope that you have found this podcast to be helpful. Remember, the Family Estate and Legacy Program is a 7-step process. The delivery or signing meeting is only the fourth step. The next steps in this process are for us to coordinate with your advisors, whether it is advisors that you previously have selected or whether you're going to meet with one of the advisors on our team. It may be related to preparation of income taxes. It may be pursuing long-term care insurance or life insurance or investments or something else. But the next step is for us to do the advisor coordination. After that is the asset alignment workshop. And then lastly, we're going to talk about the maintenance program. And as I previously mentioned, that's going to include the ability to do a family meeting. You should be thinking about scheduling that family meeting. Our preference is within the next 6 months following the delivery or signing meeting. Well, thank you so much for being with us. Have a great day. We look forward to seeing you at your delivery or signing meeting. Thanks so much.